Hi, I'm Jeremy Abrams, an attorney in Reed Smith's State Tax Group, and I'm joined by my colleague Michael Laurie, also an attorney here at Reed Smith, and Adam Krupp, the Commissioner of the Indiana Department of Revenue. Today we're going to discuss a recent case from the Supreme Court of the United States dealing with sales tax nexus called South Dakota v. Wayfair, in which the court, in a 5-4 decision issued by retiring Justice Anthony Kennedy, held that the physical presence standard for sales tax nexus is unsound and incorrect, reversing more than 50 years of precedent and opening up the doors for states to impose sales tax collection obligations on remote sellers. We're not going to discuss the merits of the case or much of the theoretical constitutional issues involved in the case. Instead, we're going to deal much more closely with the practical implications going forward for taxpayers and state tax administrators alike. So Adam, why don't we start with you? I know Indiana has an economic nexus statute similar to the one imposed by South Dakota that was the subject of the Supreme Court case. So why was this case important for Indiana, and what are your general reactions to the decision?
Sure. Well, first of all, thanks for having me. It's a pleasure to be here. In terms of Indiana and our economic nexus statute, the value for Indiana is the same as we heard from all states all over the country in terms of declining revenues, the booming e-commerce industry, out-of-state retailers sort of availing themselves to the benefits of Indiana, and purchasers within the state, citizens of Indiana, not then having those taxes collected by those retailers. We all know, just as Justice Kennedy pointed out in the majority opinion, that use taxes are notoriously low in terms of what's been actually collected. And so from a tax administrator, we're pleased with the decision. My colleagues around the country are pleased as well. This certainly, as it shifts that point of collection over to the retailers, a lot of businesses, of course, are now going to register with us. So that puts a lot on us, though, in terms of implementation, things that we need to do as an administrator to get ready for this. But with the additional revenue that will undoubtedly and inevitably come in from this ruling, it will go to things that are necessary functions of government. Whether it's transportation, health and human services, education, or public safety, Indiana views this as a positive, an additional source of revenue that's going to help go towards some of those programs.
Well, we know that the decision didn't answer all the questions. So while the states universally find, or almost universally find this as a positive development, it leaves many issues unanswered. So Mike, what are some of the primary issues that taxpayers and practitioners and state tax administrators will be facing going forward?
So I think the first thing that's going to be really upfront and center is retroactivity. This decision punted on the issue of retroactivity because the South Dakota statute explicitly said that it was not going to be applied retroactively. It would only have prospective effect. And because of that, the court didn't need to address that issue directly. Instead, the court said that that was a factor that viewed favorably in the South Dakota law, but did not say that that was a necessary factor. So I think there's going to be a lot of follow-up, maybe litigation, depending on how it plays out, about what is fair in terms of retroactivity or prospectivity of this decision. I think the second issue that's going to become much more important is due process connections. The Quill decision split nexus into two components, due process and commerce clause. And commerce clause is really focused on really discrimination and interstate markets, while due process is focused on fairness. And while this decision addressed the commerce clause piece, it didn't necessarily address the due process piece. And that could be important for some taxpayers or retailers going forward, that even though this decision might say they have commerce clause nexus, they might not actually have due process nexus. And the third thing that's going to be important is tax simplification. Another factor that South Dakota had that not every state has is that they are a streamlined sales tax member. The court said that that was an important factor to them, and it's unclear whether that is something that's also necessary. And for a lot of states, it could be extremely difficult to get in compliance with streamlined. And I think the majority of the states are not streamlined members, and the majority of the population does not live in streamlined states. So that could really be a little bit messy if lower courts have to interpret this and figure out, is streamlined something that is necessary or something that looks like streamlined in terms of tax simplification.
So going back to your first point, retroactivity, Adam, I know Indiana is a member of the Streamlined Sales and Use Tax Agreement, and you have a statute similar to the South Dakota one, so it's not retroactive. But I'm just curious, as an administrator, what are your views on the retroactive issue, and should states be trying to go collect retroactively, or should this be a prospective engagement?
Well, it should be prospective, and I'm thankful that Indiana's statute passed in 2017 was prospective in nature, at least from the point that it was enacted. In terms of retroactive application of taxes and back taxes due, the significant burden that would be placed on sellers and merchants in this space just seems unreasonable. You know, for someone to say, I was following the law of the land as it applies, as written, doing everything right, in many cases voluntarily even registering, let's say, if they were, but those that weren't, they weren't collecting, they weren't remitting because they weren't required to. I think for states to now come in and say, well, in light of Wayfair, we're going to pass this legislation and we're going to make it retroactive, or the legislation we already had on the books that was similar, we'll make that retroactive. I don't think that's good for business. I don't think that's good for the relationship between a tax administrator and the citizens, the customers. We view them as customers, the taxpayers that are ultimately going to interact with you as a government agency. It's just not the way we should be doing business, and I'm not in favor of it. And again, I'm thankful that the lawmakers in Indiana, you know, when they put their attention to the legislation for economic nexus in Indiana, made it prospective.
Well, with that said, we're starting to see reactions from states around the country, and some states are taking a different view, maybe pushing the envelope a little bit, either going retroactive or starting collection immediately, you know, following the Wayfair decision. So, Mike, what are we seeing from other states, and who's being aggressive, and what should we expect?
So I think so far the bulk of states have been saying that they are going to have prospective application. We've had statements from National Council and state legislatures that said that they recommend that states start in January 1st, 2019, so they can really get their house in order before starting compliance. I don't know that every state is following that deadline. I think some states are doing earlier than that, but with enough time to give taxpayers time to get compliance in place. Although whether how much time it will actually take to get in place is probably a big question for a lot of retailers. I think Texas has come out with guidance. A few states have come out with guidance on the prospective application. However, 2 states have publicly stated they will be applying either Wayfair retroactively, or that they already had authority to tax remote sellers who do not have a physical presence in the state. And those are Hawaii and Massachusetts. And Massachusetts in particular has this theory called cookie nexus, where they say that if a remote seller operates a website and that website places cookies on a user's computer, that is a physical presence. That those cookies, little piece of code that track the user, are actually property that constitutes a physical presence. And their position is that because they had a regulation in place effective in October 1st, 2017, that they're not actually retroactively applying Wayfair, that this is actually good law under Quill, so they can tax taxpayers back to then. I think the open question on that is whether that's just an end run around Quill, or whether Wayfair really makes it so that's a moot point and prospective application is really the right answer.
So another factor related to retroactivity, or one of the reasons behind the court's decision upholding the South Dakota legislation, was the threshold, the so-called small taxpayer protection, the 200 transactions or 100,000 in sales minimum threshold. We're seeing some lower thresholds around the country. Some states have come out and said that they'll require collection and registration at 10,000, and some have taken the opposite view and went as high as 500,000. What would your advice be to states around the country? Do you think the 100,000 in receipts or 200 transactions is a reasonable threshold?
Well, the Supreme Court certainly thought so, at least in the context of all the other factors in place. Indiana has the same threshold that South Dakota had in its laws, so we feel comfortable and confident in where we are. Well, I know there's been some remarks about the opinion that it didn't expressly endorse or say that this is sufficient, this is what the standard should be, but in terms of that particular threshold, it certainly holds weight. My advice to other states, and when I see some of the news about what other states are doing, is I would be cautious about thresholds that are lower than that. When you have a U.S. Supreme Court opinion that says, you know, 100,000 in sales, 200 or more separate transactions, no retroactivity, streamline it, you add those in, but in terms of just the threshold, why would you not follow that is sort of the approach that I would take. And if Indiana didn't have the law that it has in place, I think we would look to the Wayfair opinion and say, this is what we need to do. You know, as prior to Wayfair being released, there was a lot of talk about, well, we're inviting chaos and uncertainty. And how could I possibly comply if every state does something different? So while many states will have a similar standard, a similar threshold, I think we run the risk of inviting sort of that extra attention and spotlight. We may be creating our own chaos unintentionally if we have a lot of lower thresholds than the one that is in the Wayfair opinion. So I would be cautious with that. I hope that states that don't have something on the books right now will just look at Wayfair and say, this is what we need to do. And we'll also be hopeful that states that have a lower threshold potentially revisit theirs.
Well, I assume you must be speaking to some other officials around the country about what to expect and comparing notes or what you might do to implement this law going forward. Could you tell us about some of those conversations and efforts that you're involved in?
Sure. So as soon as the decision came out, the first thing in my mind is, well, what are other states going to do? How are we going to implement this in a way that's consistent? Because, again, when you're thinking about undue burden and avoiding chaos, you want to make sure that as many states as possible do the same thing on the implementation side to the extent that their law allows it. But in terms of reaching out specifically, talking to other commissioners or secretaries, one of the first calls that I made was to Secretary Andy Gerlach, who is in charge of the Revenue Department in South Dakota. For obvious reasons, not just because this is a South Dakota case. I thought, you know, given his background and perspective on the issue and with the threshold being put in place by South Dakota, I thought, well, who better to reach out to in terms of implementation and questions they might have already considered so that we can work together. And so Secretary Gerlach and I had a conversation just days after the decision, and we thought, all right, well, is there something we can do together? Is there a way to maybe get other state tax administrators thinking along the same lines? Either, you know, we might sort of send out a group email and invite people onto a call. Conveniently, just shortly after we started talking about that, the Streamline Board sort of announced a meeting July 19th and 20th, and both of us will be attending. My hope is that several other tax administrators from Streamline states will be in attendance as well, so that, you know, when we're not necessarily in session doing the formal meeting, that we can actually step aside and just sit down as agency heads together and say, okay, what questions are you getting? What's your staff asking? Because we need to know how to administer this fairly and properly and consistently. And let's just work through these questions together, sort of a grassroots effort, if you will, to make sure that those of us, not just Streamline, but especially those that have the same standard. I would think that needs to be highlighted. If states have the same threshold in place for remote sellers, those states should be doing the same thing in terms of implementation. So that's a big concern of mine.
So is your primary concern when you're talking with other administrators or even internally at your department, is it making sure that you do what's necessary to have your statute constitutional, or are you also keeping the smaller out-of-state taxpayers in mind? What are you doing to sort of ensure that there won't be an undue burden for the smaller taxpayers in other states?
So we always want to do what's within the parameters of the law, which we're allowed to do. That's always a focus in the back of our mind, but primarily on this particular issue, we're thinking about the business community. And I want to do, at least from Indiana's perspective, and again, hoping that others join with us, I want to do what's fair, what's reasonable. We want to allow ramp-up time so that businesses have that opportunity to evaluate the system they have in place. Some are going to have, you know, significant resources, probably a system already in place to where there might just be a technological upgrade or two. Other businesses and companies, especially smaller businesses, they're going to go out into the market, and whether it's through Streamline, through a certified service provider or otherwise, they're going to say, what technology is available to me, you know, and they're going to have to learn it. They're going to have to figure out a way to implement it, sync up with the current system they are using for their online sales. Some are going to be more sophisticated than others. And we've put a website up just for the Wayfair case that has it has an overview of the case, but it also has some instructions about how to register with Indiana, how to register through Streamline. approach you want to take as a multi-state seller. And we put a note in there that we're very genuine and serious about, which is as questions come in between now and whenever registration really kicks in, and even after that, we will answer questions and update our FAQ page so that as many hypothetical scenarios as possible are covered, because our job is to help, not to get in the way, right, as the administrator. So if businesses are struggling figuring out either how to register or how does this threshold actually apply to me, because we all can read it on paper and think it's very simple, but once people start describing their business model and talking about the types of sales they make in your state, you get a little bit more complicated. So our job is to really answer those questions and ideally put that out there on a website so that others who are similarly situated can read that and say, oh, I have the same situation, so that's how Indiana's going to treat that question.
Okay. Now, interestingly, a lot of our viewers may not realize this, but Indiana had a case pending similar to the Wayfair case that went up to the Supreme Court. So I believe currently there's an injunction in place, but what's the current status in Indiana, and when do you expect to start implementing the law?
Yeah, so as of today, we have a declaratory judgment action pending in court in Indianapolis, Marion County, where the Department of Revenue is seated. Prior to that, we did have a lawsuit come in to challenge Indiana's economic nexus law on June 30th, I believe, right before it went into effect on July 1st of 2017, that said that this is unconstitutional, cited Quill, just as you would expect. And so our statute actually had a provision that said if we file declaratory judgment action, we will be prevented from enforcing it, and the obligation will be stayed during the pendency of that action. So as of today, that declaratory judgment action is still going. In light of Wayfair, we believe we have a clear path forward, so we are talking to the Attorney General's office who represents us, evaluating the next steps in that matter, whether it be dismissal of the case or an agreed upon order. And so pending resolution of the declaratory judgment action, we're looking at October 1st in terms of an official implementation date where Indiana will go live, so to speak, and say businesses need to register with us or through Streamline by October 1st to begin imposing, collecting, and remitting back to the state of Indiana. And October 1st is a date that, through conversations with local Chamber of Commerce, CPA Society, practitioners around town, and throughout the state of Indiana, actually through an advisory board that we have, they have expressed to us that October 1st will be fair and reasonable in the business community. So that was very important. We took that to heart. There are some things that we have to do. There's questions we have to answer. There are questions the business community has to answer, work with folks to get prepared to ramp up. I know that January 1st has been recommended, but other states are going with October 1, so we're going with October 1 as well, again, assuming the declaratory judgment action is taken care of and resolved by then.
Another one of the obvious unanswered questions from the Wayfair decision is what Congress might do, whether they might step in and codify some sort of sales tax nexus standard. So Mike, do you have any thoughts on what Congress might do, or whether they should act, or if they should just let the states work this out on their own?
So I think that there is room for congressional involvement here, and I think that's going to really depend on how the states play this out. As we've been seeing, there's a couple different ways they could go, and I think that there are a few ways that Congress could get involved in a heavy way. If too many states start going retroactive, or if any states go retroactive, really, I think we could see congressional action on this. I think Senator Heitkamp from North Dakota, who was actually the Commissioner of Revenue for North Dakota when that case was there, she said that she thinks retroactivity is really the linchpin, and she said that the states need to do this perspective only, otherwise Congress really will act, or the courts will act. And a couple other legislators have already proposed the STOP Act, which would require physical presence and codify the rule from Bell's, Hess, and Quill. So I think there is room for legislation, and it's going to depend on how reasonable states are. States all take a reasonable position. I think we could slide by without any congressional action on this. On the flip side, if any states go crazy with this and view this as just a revenue source and start going back 20 years, I think we'll see a bill pass really quickly. So I think it's really up to the states.
So you mentioned revenue source. So obviously, Adam, you mentioned this might increase revenue or bring in some inevitable additional revenue. Do you have any estimates in mind or what you plan to do with that additional money?
So as we look at this, we try to do our own internal estimates. I know there's public figures out there for Indiana and what the impact is. We're comfortable saying tens of millions of dollars, which is not going to be a tremendously significant impact on our budget as a state. I don't think that people should use this as an opportunity, not just on the retroactive question, but people shouldn't use this as an opportunity to get greedy. There are programs in Indiana that are funded, that are very well funded, and there are also programs that might need a little additional funding as we move forward. I think our General Assembly and the lawmakers in Indiana will want to know from me and the folks on my team as we play this out, what type of dollars are we seeing once we develop a benchmark and kind of level set with what the future looks like, probably sooner, sooner than later. We'll be able to start appropriating some of that additional revenue to other programs or initiatives, but time will tell, really, on the answer to that.
Okay. So there are numerous additional questions that we didn't address today. For example, whether states might try to enact economic nexus through regulation rather than legislation, or whether this might expand to other tax types beyond sales tax or other industries, for example, the asset management industry, through look-through provisions. But for now, we'll finish off with some final thoughts. We'll start with you, Adam, and then Mike will give you the last word.
So in terms of final thoughts on this issue and in the case in general, it's obviously a historic case. I am pleased with the way it came out, not just as a tax administrator, but also the former litigator and the lawyer in me. I like to tell folks the story that when I took the job in January of 2017, people said to me, "You really need to know about this case called Quill." I said, "Okay, somebody pull that for me so I can read it." And I read it as a lawyer because I was fairly new to the game of tax administration. The lawyer and the litigator in me read Quill and thought, "This is wrong. Surely this is going to get fixed. The internet has changed everything. It seems like the Supreme Court will take this case and this issue very soon, and ultimately when they do, there was no doubt in my mind they were going to overturn Quill." Fast forward a year and a half to my role as a tax administrator, being surrounded by practitioners and folks that felt very strongly about preserving Quill, and then I guess my judgment got clouded a little bit. And I started to think they're not going to overturn Quill, even though I always believed they should. Attended oral argument when Wayfair was heard and walked out of that. I know as a lawyer, you're not supposed to base your thoughts or opinions on what you hear from a bench or how you evaluate a jury in other contexts. I guess I couldn't help myself because then after the hearing, as you know, 75 practitioners got in a room and all explained why, based on that oral argument, they're not going to overturn Quill. You were probably one of them saying the same. And so then I changed my tune a little bit. But at the end of the day, you always stick with your gut. So as a lawyer, someone who reads it with that eye, but also as a tax administrator, I'm pleased with the outcome of the Wayfair decision. I think it's the right ruling. And I look forward to working with the business community to really collaborate and figure out how this registration process and the implementation of our economic nexus law is going to be fair and reasonable for everybody. Also, while inviting other states to sit down with folks like myself and Secretary Gerlach, and let's work together and let's figure this out.
Great. Mike?
I think that the writing was on the wall that Bellis, Hess, and Quill were in serious danger back when Justice Kennedy wrote his infamous concurrence in Direct Marketing Association a few years ago. He just directly invited the challenge, and when the Supreme Court justice says that, everyone needs to take it seriously. South Dakota really followed up with essentially the perfect legal strategy. Take away all the court's concerns they expressed in Quill. No retroactivity, simple sales tax, everything is lined up perfectly. The court takes up the case, overrules Quill, and the problem is that all they answered was, what happens when we have that simple test case? And now everyone else is left with this complex situation that doesn't have this simple fact pattern, this essentially test case up there. And I think that's going to be the next few years, is figuring out the aftermath of Wayfair.
Great. Well, thank you very much. Thank you for being here.
Thank you.